Sentencing in a federal criminal case is always a confusing adventure for those people who haven't had any experience dealing with it. And I've done videos in the past about that. But there are changes that are coming effective November 1st to how this sentencing process works, specifically how the guidelines might be applied in everybody's case. So that's what we're talking about this week. So stick around and we'll discuss the first of those amendments on this week's video. Happy Friday, everybody. Hope you're having a great week. And a while back, I did do a video on how the sentencing guidelines work in a federal criminal case. So I highly recommend you go check that video out, get kind of a basic understanding of what the guidelines are, how they get calculated, how they work before you go any further. Because this week, we're going into a little bit of a deeper dive into some of the specifics about those guidelines. Specifically, those guidelines are written by a commission, the United States Sentencing Commission. Okay, they meet and they discuss these guidelines. They discuss what amendments need to be made, what needs to be changed, and every year they put out a book, the sentencing guidelines, that really help dictate how sentencings are going over or throughout the entire country. It's how throughout the whole country, in an ideal world, there wouldn't be these disparate sentences where somebody sentenced in California gets an incredibly different sentence from somebody sentenced in New York or Texas, because they all come back to this one set of guidelines that these federal judges are supposed to use as a starting point when they're determining a sentence. So this, like I said, this commission meets, they discuss these amendments. They haven't been able to meet in several years because various members went off of the committee or resigned from the committee. They were not able to get replacement members. So they haven't had what's called a quorum in, I think, almost 5 years until very recently. This is the first year that they've been able to get together and discuss and vote on some proposed amendments. So starting November 1st are when these amendments are going to become effective. That's when these go into effect, and that's when they're going to start being applied in federal criminal cases. So I wanted to do a series of videos discussing some of these amendments and some of the ones that you might hear from if you or somebody that you know is going through a federal criminal case, because I have started getting a whole lot of calls from clients, family members of clients that say, hey, rumor is that there's these big changes that are coming on November 1st. How does that affect my case? And the answer I always try to give them is, well, it really depends on a case-by-case basis, but here's how some of it works. So the first amendment that is coming into play deals with something that has been known for years as compassionate release. Okay, this is a mechanism by which somebody that is serving a sentence in federal prison can try to get their sentence reduced for various reasons, generally speaking, medical reasons or age-related reasons or health reasons or something like that. Like I said, it's known as compassionate release, even though compassionate release really doesn't appear in the text of the actual law. So for the longest time, this idea of compassionate release was set up to where the only people that could file a motion asking that an inmate's sentence be reduced for these compassionate reasons, the only people that could file that motion was the Bureau of Prisons. The inmate couldn't file it on their own behalf. Their lawyer couldn't file it on their own behalf. The BOP were the only people that could file that motion. So they were kind of the gatekeepers of who would get considered for this type of release. And as you can imagine, they were very, very stingy about how they applied for this type of relief from the courts. It did not happen often. So back in 2018, there was something put into place that allowed for inmates to file on their own behalf for this compassionate release. And then that was codified even further with the introduction of the First Step Act. So the First Step Act actually amended the statute and it allowed inmates and prisoners and defendants to file this motion on their own. They no longer had to wait until the BOP filed that motion. So the First Amendment to the guideline deals with that. It really takes that idea and it puts it into the guidelines. It talks about not only are defendants allowed to file this motion on their own behalf now, but it talks specifically about what types of things they're allowed to file this motion for and what should the judge consider when looking at a motion like this. It talks about if the person has severe health conditions, that means that they're going to require long-term care. If they're over the age of 70 and they require various health issues or doctor's treatments or anything like that, just that comes along with old age. It talks about if the person has been the victim of any kind of abuse during their incarceration, be that sexual or physical or anything like that. That is something that the court can and should consider. Another really important one is if it is what they call an unusually long sentence and they've served at least 10 years. So if somebody receives a sentence of 30 years, 40 years, 50 years, and they've served at least 10 and they no longer pose a danger to the community, that is something that can now be considered by the judge to determine whether or not that person should have their sentence modified. So there are a host of reasons, and I'm not going to go through each and every one because the text of the amendment is actually pretty long. And what I'll do is I'll post a link down here so that you can look it up and read it if you're interested. But really what it does is it broadens these categories of reasons by which somebody can now file this motion and request a sentence be modified and they be released early because of some of these medical conditions or health conditions. Or another one is if they have a child at home and the other parent dies and now they're going to be the sole caretaker for that child. That's another reason to apply for this type of release. So it is very interesting. It's going to be interesting to see how this goes into effect, how many of these motions we start to see, and how district judges really start treating them. I know throughout COVID, throughout the pandemic, we saw a huge number of people applying for compassionate release saying that they were impacted by COVID, or they caught COVID, or they were treated for COVID, or they were isolated because of COVID. And at least here in Texas, there was a hesitation by judges to grant many of those motions unless it was an extreme circumstance. So now that there's this amendment put into place, I'm really curious to see if judges become a little bit more lenient with granting these types of motions, because there is some guidance from Congress that says, hey, you really should give a long, hard look at these specific cases. As always, if you have any questions about this or anything else, feel free to reach out via telephone, email, whatever, and I'd be happy to discuss this with you. Look for my continuation of this series next week. I'll start moving on to some of the other amendments that are going into effect November 1st. But until then, hope you all have a great weekend, a great start to next week. Be good and stay on the right side of the bars.